The sidewalk was empty. A man sat quietly distributing flyers in a residential neighbourhood. No shouting, no trespassing, just paper in hand gently folded on his lap. On another day, in another place, perhaps it would have gone unnoticed. A democracy functioning quietly in between campaign cycles. But in West Des Moines, Iowa, that sidewalk would become the stage for a constitutional crisis. It would last just minutes, but legally it would echo far longer. The footage begins with Officer Ray initiating an interaction under an unremarkable pretense, a call to police about a suspicious person. The reported reason: a black man handing out flyers, wearing a jacket and hat on a 67-degree day. That's it. Not harassment, not threats, not property invasion, just a black man, politically engaged, visibly present. And for some, that's reason enough to place a call. From that call emerges what appears to be a standard police approach. But bodycams don't just show us actions, they record patterns. And here, the language begins to matter immediately. Officer Ray initiates conversation using indirect authority. Not demanding, not accusing. He walks a verbal tightrope, telling Keelan that neighbours had concerns. The implication is both vague and strategic. It softens the authoritarian edge, but plants a seed. You're being watched. Keelan's response is calm, unmistakably aware. He asserts he's done nothing illegal. He states clearly and early that he's not soliciting. He's distributing political material, a constitutionally protected act under the First Amendment. He hasn't asked anyone for money, and he hasn't trespassed on private property. It's in this restraint, a man choosing measured defiance over emotional reaction, that the encounter's asymmetry becomes visible. One person stands with authority, weaponry and command presence. The other stands with knowledge, and that's precisely what Officer Ray begins to resent. As the discussion continues, the officer subtly transitions from question to control. He asks for ID, for name, for cooperation. Keelan rightly declines, citing that he hasn't broken any laws and is not under arrest. The Fourth Amendment protects him here. The Supreme Court made that clear in Terry v. Ohio, 1968, and Hebel v. 6th Judicial District Court, 2004. Unless an officer can articulate a specific reasonable suspicion that a crime is being committed, a citizen has no obligation to identify themselves or remain. But Officer Ray either misunderstands or chooses to ignore that legal threshold. Instead of articulating a crime, he leans on the original premise that someone found Keelan suspicious. He repeats this word like a shield, as though public panic alone justifies police action. In law, it doesn't. Suspicion, without supporting facts, is an opinion, not a predicate. By minute 4, Keelan asks his first crystal-clear legal question. Am I under arrest? The officer says no, but still insists Keelan cannot leave. This is no longer a consensual encounter. At this moment, without lawful justification, the encounter becomes a de facto detention. Many officers fail to recognize the gravity of this shift. Verbally, they avoid the word detained, but operationally, they enforce the boundaries of detention. That legal grey zone becomes dangerous, quickly. And in bodycam footage like this, it is often the source of constitutional collapse. Keelan's response is airtight. He says he's walking away. He states clearly that he's invoking his rights. He presents himself as peaceful, professional, and informed. A politically active citizen waiting for a line officer to remember the law. But that recognition never comes. Instead, Officer Ray calls for backup. What's striking here is not just the fact that backup is called, but the reasoning given over the radio. The officer reports that Keelan is uncooperative and refusing to identify. But those facts are out of context. Keelan is only uncooperative if legality is assumed. He's refusing to comply only because compliance here isn't required. Yet broadcasting this information to dispatch sets a tone that paints lawful conduct as obstructive. This pattern of preloading the narrative is common in problematic stops. Officers build their case not through facts, but through radio conditioning of perception. This is how the language of non-compliance becomes weaponized. By minute 8, the interaction has degraded into a standoff of principle. Keelan walks slowly away, only to have the officer follow, warning that he'll be detained if he doesn't stop. The officer's tone has hardened, his authority now backed not by law, but by inertia. And this is where the shift fully occurs, from investigatory questioning into unlawful detention. Even in this moment, Keelan remains composed. He doesn't flee, he doesn't raise his voice, but he asserts, with legal accuracy, that this is a public roadway, and he has done nothing wrong. He knows his rights. He uses foundational phrases with surgical precision, and in doing so, he peels back the illusion of the encounter, that this stop is grounded in law, when it is actually built on judgment, race, and frustration. Officer Ray eventually makes good on his threat. He puts Keelan in handcuffs, on camera, without ever articulating a crime. The legal weight of this decision is devastating. False arrest, improper detention, Fourth Amendment violation, First Amendment chilling effect, potential abuse of Terry standards, interference with political speech. Every claim, stacked like a deck of cards, is filmed and time-stamped on the officer's chest. What makes Keelan's situation uniquely powerful is its banality. There is no danger, no pretense of resisting arrest, not even clear disagreement on facts. This isn't chaos, it's clarity. And that clarity is why Officer Ray's conduct is so damaging, because it reveals just how trust in authority is broken not through violence, but through policy enacted by habit. Keelan, for his part, speaks truth to power, not with rebellion, but with restraint. He continues to ask what law has been broken. He continues to reject unlawful commands. And he continues to document the event, invoking not violence, but visibility. That visibility would later become evidence. Officer Ray then justifies his behaviour by claiming Keelan's refusal to stop or identify himself amounts to interference with a police investigation. But interference only exists when one willfully obstructs a lawful exercise of authority. And for an exercise of authority to be lawful, it must be based in reasonable suspicion. In this case, the officer had none. More importantly, video evidence, collected at the scene and through dispatch records, would later prove that claims of property trespass or multiple concerned neighbours were false or unsubstantiated. That lie effectively detonated any qualified immunity Officer Ray may have hoped to maintain. In the language of constitutional law, this is no longer a mistake, it's a pattern. A lawsuit soon followed. But by now, the event had already entered a second phase, public consequence. Keelan, a young black man hoping to enter law school, now had an arrest on his record, delivered not by merit, but by misconduct. And with it came legal fees, psychological trauma, digital footprint damage, and the slow, grinding anxiety of litigation. This stop cost the officer nothing in the moment. It cost the citizen everything. Part 1 closes here, but it leaves behind an open wound. What began as a vague call about suspicious behaviour unravelled into a textbook study in collapsed probable cause. And through it all, Keelan remained calm, grounded, and self-protective, armed with nothing more than his phone, his words, and his knowledge of the law. But none of that stopped handcuffs. In Part 2, we turn deeper into those handcuffs, into the legal aftermath, the case filing, the constitutional violations that span not just minutes, but federal codes. Because bodycam footage is only the first step. The direction it takes in courtrooms and in policy is what defines accountability. When the handcuffs finally close around Keelan's wrists, they lock down more than a man. They bind the full spectrum of civic trust, trust in due process, in restraint, in institutional self-correction. What began on a public sidewalk as an unlawful stop is now a formal arrest. And though Officer Ray utters the word interference, this invocation is not backed by law, it's backed by momentum. A trajectory already set in motion, driven not by facts, but by pride, profiling, and protocol disguised as procedure. At the heart of what follows is the Chamdi's Daishkapio Forthonium, Iowa Code Section 718-5 a statute criminalizing interference with official acts. Like many interference statutes across the United States, use rests entirely on whether the officer acted lawfully in so. in the moments preceding a citizen's refusal to comply. If the officer lacked legal justification to stop, question or detain, then refusal is not resistance. It's protection, but that distinction is lost in this field interaction. Officer Ray radios dispatch, citing non-compliance and refusal to identify as the grounds for arrest. But the arrest isn't based on any actual crime, only on Keelin's refusal to accept the officer's overreach. In short, he is arrested not for what he did, but for what he refused to do. And what he had every constitutional right to deny. As we revisit the pivotal scene, now from the lens of legal consequence, the contrast hardens. Keelin, by all existing constitutional rulings, should have been free to walk away. His refusal to identify himself wasn't defiance. It was a constitutional exercise. Repeated Supreme Court decisions have backed this principle, most notably in Callender v. Lawson, 1983, where the court struck down laws requiring credible and reliable identification without reasonable suspicion of a crime. But Ray resists not Keelin's behaviour. He resists Keelin's knowledge. It's this dynamic that undergirds so many modern Fourth Amendment abuses, not aggression from citizens, but literacy about their own rights. And in this footage we see that literacy punished minute by infuriating minute. A turning point in the footage arrives without fanfare, no escalation in body language or speech. It's when Keelin finally verbalises what many victims of profiling feel but cannot always prove. That grounding all of this is race. He tells the officer plainly, "You're suspicious to me, a white man with a gun." His words, sharp and chilling, reverse the lens for just a moment. They lay bare the assumption beneath the officer's logic, that a black man in a white neighbourhood, carrying papers instead of tools, dressed in layers rather than shorts, talking to strangers he doesn't know, must explain himself. That unspoken assumption is the very fulcrum of racialized policing. Shortly after this, Ray uses Keelin's justified frustration against him, citing his use of obscenity in a public space, subtly suggesting disorderly conduct. This tactic isn't new. In moments of disadvantage, citizens, especially black men, know that tone can be used as justification for power. The law, however, offers clarity. City of Houston v. Hill, as of 1987, ruled that citizens may verbally challenge or criticize police without risking arrest, as long as no true threats or physical aggression ensue. Still, the badge becomes arbitrator of the moment. Ray's escalation enters a second phase, narrative control. Over the radio, he distills a complex, rights-driven encounter into a sentence. He kept walking away. Interference. It's a summary designed not for accuracy, but for internal legitimacy, framing the arrest for peers and later for departmental review. Officers often understand that the initial report conditions the next layer of oversight. In mischaracterizing the interaction, Officer Ray builds a buffer around his own decision-making process. And yet, the Bodycam resists spin, because it remembers everything. Soon, Keelin's voice changes. He's still calm, still assertive, but behind his words a shift emerges. The frustration of someone who knows he's not just being ignored, he's being penalized for knowing his rights. He declares he's been stopped twice in 2 days, on both occasions, for walking while campaigning. And in each instance, neighbours called the police not because of actions, but because of presence. The implication is unapologetically uncomfortable. He isn't standing trial for what he did. He's being judged for where he is and who people assumed he might be. This is how structural bias operates, not through explicit acts, but through compounded assumptions. Through silence in report logs, through repeated stops lacking substantiating evidence, through vague language used in dispatch summaries, and through habitual deference to the narrative of the officer over the lived experience of the citizen. The arrest, as laid out, is legally indefensible. The backup officer arriving at the scene offers no independent analysis, no grounding clarification. Instead, he defaults to Ray's framing. Non-compliance equals interference equals arrest. Keelin is logged, cuffed, and removed. Due process begins after the fact. Too late to stop the damage. Civil repercussions would soon reach the surface. A federal lawsuit is filed under 42 U.S.C. Paragraph 1983, which enables private citizens to sue state actors for constitutional violations conducted under colour of law. The lawsuit accuses the West Des Moines Police Department and Officer Ray directly of violating the First Amendment by interfering with political speech and punishing the act of campaigning. The Fourth Amendment through unlawful detention, lack of reasonable suspicion, and the false arrest that followed. The Fifth Amendment, coercing identification in the absence of legitimate detention. The 14th Amendment, failing to apply law equally and targeting the plaintiff based on race and locale. The complaint seeks to bore $1.5 million in damages, not only for emotional distress, but for the derailment of Keelin's pending law school applications and political career. And as it unfolds in the circuit court system, it does so not as a singular incident, but as part of a broader national ledger of Casposo, police encounters that begin lawful and end lawless. Because that's what this footage documents. A stop made on impulse. A lawful presence turned to suspicion. A video that exposes not accidental poor judgment, but a rehearsed pattern of control, built on institutional power rather than citizen protection. It also exposes the parallel justice system embedded in modern encounters. While police talk in terms of suspicious persons, the system offers little scrutiny into the suspicious logic used on public sidewalks. The parallels to Hebel, Warren and Terry are not theoretical, they're functional. Case law exists. Statutory precedent exists. Local ordinances prohibit what happened, yet it still happened, precisely because pattern recognition has not yet become reform. Keelin's plain-spoken commentary at the end of the video, recorded after release, does what no legal citation can. It humanises the policy failure. He doesn't shout. He doesn't beg. He outlines, systematically, how his presence alone has triggered police stops. His tone is analytical, not angry, and in that, it becomes more damning than outrage, because he sounds like exactly what he is. An informed black professional, methodically documenting the mechanics of his own profiling. That testimony, grounded in calm but undeniable resolve, is what makes this arrest so symbolic. It's difficult for departments to claim training gaps or aggressive behaviour here. Everything is slow, peaceful, legally navigated in real time, and still. Keelin ends up in handcuffs. This isn't about degrees of suspicion anymore. It's about how suspicion itself is manufactured, curated, sold, and reinforced. And how the burden to disprove it falls disproportionately on those without badges. Part 2 ends here, but the legal journey is just beginning. What happens next won't be debated on a sidewalk. It will unfold in case briefs, testimony transcripts, and the fine print of qualified immunity doctrines. In Part 3, we'll trace the lawsuit's national implications. Because this isn't just an incident in Iowa. It's a warning for every jurisdiction, for every neighbour using 911 to define their own comfort zone, and for every officer who thinks suspicious is still a passcode for unchecked authority. As we move into the final chapter of this case, the footage is no longer the focal point. It now becomes evidence, hard, permanent, legally admissible evidence in a federal civil rights suit carrying national implications. The lawsuit filed by Keelin doesn't just seek compensation for an unlawful arrest. It points directly at the structural failure of a system where ambiguity in officer discretion becomes a shield for unconstitutional behaviour. And in doing so, it questions not only what protections exist on paper, but who those protections are designed to serve. The path forward for this case is framed by 42 U.S.C. Paragraph 1983, one of the most important civil rights statutes in American law. It allows individuals to sue government actors, including police officers, who violate constitutional rights under colour of law. Civil lawsuits like these form the unseen infrastructure of accountability, where the courtroom becomes the last venue for rights denied in plain view. In Keelin's lawsuit, Four constitutional themes structure the case. First Amendment. He was participating in political speech, handing out campaign flyers in a public area, an act protected at the highest level of scrutiny. Fourth Amendment. He was detained without reasonable suspicion, arrested without probable cause, and subjected to state power without lawful justification. Fifth Amendment. He remained silent and refused to identify himself, as was his right. Yet those refusals were treated as evidence of wrongdoing. 14th Amendment. The treatment he received was discriminatory in nature, pushed forward by vague accusations and subjective fear, rooted in his race and presence. Nowhere in the footage, despite its nearly half-hour runtime, is there any moment where probable cause emerges. No evidence of trespassing, no confrontation with residents, no physical threat, no illegal object. What we see is the total absence of a criminal act, and yet the outcome mirrors one. That incongruity is what makes this case so injurious. When the processes of criminal justice are applied without the substance of a crime, the Fourth Amendment becomes not weakened, but optional. Keelan's legal team knew this, and based their argument on more than emotional appeals. They anchored it in case law. In Florida v. Royer, 1983, the Supreme Court held that law enforcement officers may briefly detain a person if they have a reasonable, articulable suspicion that criminal activity is afoot. But that standard is not subjective. It cannot rest on gut feeling, community discomfort, or racial perceptions. It must be justified by specific and observable facts. Officer Ray offered no facts, only a call from a resident, and that call said nothing about a crime. That disconnect becomes the legal fault line. What makes Keelan's lawsuit more than just another civil rights filing is the comprehensive failure across every layer of the interaction. Consider the language used by Officer Ray. He cites interference as a crime while failing to explain what duty Keelan obstructed. He uses suspicious person, not as an evidentiary classification, but as a recurring justification, as though if repeated often enough, it will gain legal status through brute persistence. But repetition does not create constitutionality. If anything, it reveals lack of substance. Federal courts have consistently weighed in on such logic. In Brown v. Texas, 1979, the court struck down a case where a man's refusal to identify himself led to arrest, though the officer had no reasonable suspicion. What the court said was clear. Absent evidence of wrongdoing, officers cannot compel identification, and refusal to provide ID cannot be treated as a crime. This is nearly identical to Keelan's case. Yet even with this precedent, the arrest was made. That's what this documentary must highlight. Not just what happened, but how it continued to happen well after it was legally indefensible. Let's turn now to structural immunity. Qualified immunity is a legal doctrine emerging not from statute, but from a patchwork of Supreme Court decisions, offering government officials liability protection unless they violated clearly established statutory or constitutional rights. It's a shield designed to separate honest mistakes from intentional overreach. But increasingly, it's used as a blanket pardon, allowing officers to ignore precedent unless confronted with nearly identical fact patterns. In Keelan's case, does precedent exist? Yes. Multiple rulings at both federal appellate and Supreme Court levels hold that a person cannot be arrested for refusing to identify themselves, absent reasonable suspicion. Political speech, such as distributing flyers, is protected. Being called suspicious is not a legal basis to detain without explainable facts. So this is not a bold new frontier in police encounters. It is settled constitutional law. If qualified immunity protects Officer Ray, it's not because of unclear law. It's because of institutional unwillingness to confront unconstitutional behavior, performed calmly, quietly, with the veil of professionalism. That's often what bodycam footage reveals. Not brutal violence, but bureaucratized abuse. Keelan's video never needed adrenaline to be damning. It needed only indifference from those tasked with upholding the Bill of Rights. And that's exactly what it captured. What began as a disagreement over ID became a field deployment of state power against a lawful citizen. That's not protection. That's performance. And crucially, the lawsuit isn't an isolated solution.
It's symptomatic of deeper systemic drift. The reality that many Americans, especially black professionals like Keelan, must legally prepare for encounters, not because they break the law, but because they obey it too slowly, too confidently, all while wearing the wrong clothes in the wrong place. This isn't theoretical. The aftermath is material. As Keelan stated, he was campaigning. That campaign was tied to a sitting US representative. The arrest occurred in view of the public. The accusation, refusal to comply with lawful orders, becomes publicly accessible. Job prospects, academic reviews, and social trajectory shift instantly. Keelan's future in law was not derailed by a guilty verdict. It was stalled by the appearance of criminality, manufactured through arrest without cause. The 14th Amendment covers equal protection under the law, but in practice, that only lasts until someone labels you suspicious. And when that word is allowed to stand in for probable cause, it becomes a linguistic end run around constitutional boundaries. What happens next matters more than any one arrest. Will the court allow this to pass as routine enforcement? Will qualified immunity endure another challenge unmarred by
violence, yet built on clear illegality? Will the city settle quietly, shielding records from public inspection? Or will reform, true enforceable reform, emerge from this infraction? These questions drive debates far from Iowa. They echo in Louisiana, in Georgia, in Oregon, in every interaction where bodycams exist not to stop misconduct, but to wager how little misconduct the public will tolerate. We see the future of enforcement in moments like this, not through lawsuits alone, but in whether officers rewrite their field behavior after losing legal cover. Not retraining seminars, not new policy PDFs, field behavior. Because Keelan's arrest isn't aberrant, it's pre-coded. Its language was pulled from thousands of similar encounters. The words suspicious and uncooperative appear not because they are accurate, but because they are undeniably convenient. Convenient in justifying force, convenient in writing reports, convenient in sidestepping constitutional scrutiny. But when power becomes too convenient, democracy becomes too endangered. As the footage ends, Keelan's voice returns, no longer directed at the officer, but at the state, the viewers, and the court. He narrates what happened, uninterrupted. Peaceful protest, political flyers, 2 police stops, 1 arrest, and nothing illegal documented beyond his refusal to let his rights be stripped without resistance. If accountability ever begins, it begins here. Not with shouting, not with lawsuits, but with recordings, with patients in control under duress, with citizens who remain lawful and are arrested anyway. This is what the footage teaches, that the rights you know do not protect you, unless you're fortunate enough to also record the moment those rights are ignored. Keelan's case asks a question no officer answered on the street. Who protects the lawful, when suspicion is enough to call the law upon them? Answering that means lifting the lens beyond 1 sidewalk, 1 officer, or 1 call. It means asking where policy must end and where principle must begin. This footage is not magnetic because it shocks. It is significant because it confirms what many already live, that lawfulness can be dangerous, that knowledge can be threatening, and that change will demand more than knowledge. It will demand cost, financial, political, and personal, for those who refuse to follow the Constitution they swore to uphold.